In the last class, we have discussed what are the rights and liabilities of the principal and agent, what are the personal liabilities of the agent, etc. Today, we will discuss what is the position of the principal in relation to the third parties, what is the position of the principal and agent in relation to the third parties, and how the agency will be terminated.
Relation of principal with the third party. Before discussing the matter, we will discuss what is the agent's authority. Extent of agent's authority. Section 226 of the Indian Contract Act 1872 says that the authority of the agent to bind the principal may be the actual or real authority and the ostensible authority. What is the actual or real authority? When the principal confers the authority on the agent, it is called the actual or real authority. It may be expressed, it may be implied. And what is the ostensible or apparent authority? When an agent is employed for a particular business, persons dealing with him, that is the third persons, they can presume that he has the authority to do all such of acts as are necessary or incidental to such business. Such authority of the agent is called ostensible or apparent authority. Now, what is the position of the principal and the agent relation to the third party? This is discussed under the three heads, where the principal is named, where the principal is unnamed, and where the principal is undisclosed. First, we will discuss where the principal is named. If the principal is named, the acts of the agents are the acts of the principal. If the agents act within the authority of the principal or in the course of employment, the principal is liable for the acts of the agent. When the agent exceeds his authority. Section 227. Suppose P is the principal. He is the owner of timber factory and the shirt factory. P, the principal, authorized A, who is the agent, to procure an insurance on timber factory, only the timber factory. But A exceeds the authority. He procured the insurance for both the factory, timber factory and the shirt factory. In that situation, P is bound to pay the premium for the policy of timber factory but not for the shirt factory because agent exceeds the principal's authority. Section 228 says that where the agent acts beyond the principal's authority and this work cannot be separated from the rest. Rest means the work done within the authority. The principal may reject the whole transaction. Suppose P, who is the principal, authorized A, the agent, to buy 50 balls. But A buys 50 balls and 40 bats with the money given by the principal. P may repudiate the whole transaction. In the case of named principal, notice given to the agent as notice to the principal. Section 229. If any notice for or information is obtained by the agent in the course of the agency, the principal is bound by such notice or information as if the notice or the information is obtained by him, by the principal himself. Agency by estoppel. Section 237. Suppose A, who is the agent, tells T, who is the third party, that he is the agent of P, the principal. P does not object to the statement of A. We know that silence is equivalent to speech. In that situation, later T, who is a third party, supplies goods A and A pretends to be the agent of P. P in that situation is liable to pay the price to T. Misrepresentation or fraud of agent. Section 238. For misrepresentation or fraud committed by the agent in the course of business for the principal is liable as if these are committed by him. Now, in the case of unnamed principal, on behalf of the principal, when the agent into the contract, he enters into the contract with a third party, but agent does not disclose principal's name. The principal is liable for the contract of the agent unless there is trade usage or custom or express or implied condition which makes the agent personally liable. This is the exception. Here, principal's existence is disclosed but not named. In the case of undisclosed principal, the agent is like an independent person when he conceals both name and existence of the principal. If the principal is undisclosed, the third party can sue against the principal or agent if subsequently the principal is discovered. Now we will discuss how the agency is terminated under section 201. Agency is terminated by the act of the parties and by operation of law. By act of the parties, the first one is agreement. If there is any agreement between the principal and the agent regarding the end of the agency will be terminated by mutual agreement of principal and agent. Revocation by the principal. If the principal revokes the agreement, if he is unwilling to continue the business, then the agency will be terminated. In that situation, the notice must be issued by the principal to the agent regarding the termination of agency. Revocation by the agent. If the agent is unwilling to continue to be the agent, if he is unwilling to be under the authority, under the supervision, under the control of the principal, then the agency will be terminated. In that situation also, the agent is bound to give the notice, the information to the principal. Unless and until if there is any damage, the principal and the agent, if the notice is not given by the principal or the agent, in the case of revocation by the principal or in the case of revocation by the agent, if there is any damage, both the principal and the agent is liable to give the compensation. By operation of law, performance of the contract. If the agency is created for a particular business, after the completion of the work, after the accomplishment of the object, the agency will be terminated. The next one is expiry of time. Suppose agency is created for a particular period of time. So after the expiry of this period, the agency will be automatically terminated. If it is before the completion of the work, it will be terminated if the time is expired. Death and insanity. If the agent or principal dies or they have come to be insane or unsound mind, then agency will be automatically terminated. By Operation of law, there is another point, insolvency. If the principal has come to be insolvent, the agency will be automatically terminated. Destruction of the subject matter. The agency is created to deal with a particular subject matter. If this subject matter is destructed, it is damaged, agency will be terminated. Principal becoming the alien enemy. Suppose the principal and the agent, they are the alien. Suppose principal is the citizen of country X and the agent is the citizen of country Y. And the two countries are, if the two countries are in peace, the agency will be continued and the agreement is valid. But if war breaks out between the two countries of the principal and the agent, then agency will be terminated. Dissolution of a company. Agency is created under a company. If the company is dissolved, agency will be terminated. The last one is termination of sub-agent's authority. If the agent's authority is terminated, the sub-agent's authority automatically puts to an end. So, no more today, ending here. Thank you.